Welcome, everybody. This is our first Cyber Policy Center workshop of the new school year, and we're doing it in a new location here at Stanford Law School. And we couldn't have a better speaker than our director on the program of platform regulation, Daphne Keller. I'll just say, for those of you who haven't joined us before, you can see we have a elaborate setup for these Cyber Policy Center workshops, and so we've got our Zoom that we do every week to the thousands around the world who are watching, as well as to put on our YouTube channel afterwards. And so every Tuesday at 1 p.m. Pacific, we'll have these hour-long workshops with lunch available at 12:40 right beforehand. And the Cyber Policy Center workshop, deals not just with legal issues, but also issues related to social science and technology. And we'll also bring in some other folks this term from the platforms, from government, to talk about various issues related to technology, democracy, well-being, platform regulation, et cetera. So today, it's wonderful to kick off the year with Daphne Keller, who, as I said before, is the director of our program on platform regulation. She's going to be talking about platform law and the Supreme Court cases from last term and maybe upcoming terms. And so she'll talk for 20 minutes, half an hour, and then we'll open it up for questions. Those of you on Zoom should put the questions in the Q&A, and they will magically appear on my phone, and I can ask her questions. So we usually have a conversation right after the speaker delivers remarks, and then we'll open it up for questions from the audience. So thank you very much, Daphne.
Thank you, Nate. Can you guys hear me okay if I talk with this microphone? Oh, you guys in the room can hear me. Anyhow, all right. So I am here to talk about the big Supreme Court cases that came down about platform regulation over the past two terms. And that will make this a little bit like a 3-year-old telling a story, like, and then. But I will attempt to pull out some big themes and animating principles and not make it too much of a lecture. Okay, so just to situate us, prior to the 2022 to 2023 term, there had been pretty much a 20-year gap since we had really heard from the court on the regulation of speech platforms. The closest cases I would say to, well, I think these two count, but we had the Grokster case on copyright liability in 2005, and then we had a big First Amendment case in 2004. But the other cases people might think of as platform cases are things like Packingham. That's the one where the court somewhat recklessly referred to platforms as the modern public square. But that was about whether a state could stop individual users from going on social media. It wasn't about governing the social media themselves. And throughout that period, especially closer to the end of it, there were a lot of people who wanted to take platform cases to the Supreme Court. I think they got a lot of cert petitions about the big immunity statute known as Section 230, but there was this long time when nothing changed very much. And then in the past couple of years, that totally changed, and we have had a deluge of cases. Why did that happen? I think we all know, right? Like, there's been this huge shift in public focus on issues of platform power. The techlash is, I'd say, about a dozen years old in Europe, a little younger here. There were major political developments against Section 230 in particular from the Trump administration. Also, Supreme Court Justice Clarence Thomas keeps writing up these opinions that basically say, hey, please bring me some platform regulation cases. I would like to rule on some of this stuff. So that's backwards. Oh, there we go. So these are the cases that I'm going to cover, and I'll try to go faster through the first ones since they're not as recent. In 2023, we had two cases that were about platform liability for bad stuff that users did or posted, in this case for whether the ranking algorithms on Twitter and Facebook and YouTube could be a source of liability for harms from an ISIS attack. And that's the kind of case everyone had been waiting for and expecting for a long time. It's about when bad stuff can be attributed to platforms. But then this past year, we had a bunch of cases that were much more like issues that came to a rapid boil in just a couple of years recently. These were cases about how government can tell social media what to do with users' speech, or how government interacts with social media. So there was Linka v. Fried, which is about government actors themselves when they're on social media. There was Moody versus NetChoice, which is about the Texas and Florida social media laws, so-called must-carry laws, that required platforms to carry content against their will or effectively did so. And Murthy v. Missouri, which is the case about the Biden administration sort of informally putting pressure on platforms to take down lawful but dangerous COVID misinformation, and so forth. Some themes from these rulings that I think are noteworthy. So I'm really proud of our Supreme Court. I feel like they've been total grown-ups about this. They have mostly issued rulings that were narrow and cautious and spoke to the issue they were pretty sure they did understand and didn't have a bunch of collateral consequences for the things that they didn't understand. And this is in a context where they had stacks of amicus briefs urging them to kind of casually reinterpret Section 230 in the middle of a First Amendment case, which is what Texas was asking them to do in the Paxton and Moody cases. So good, thumbs up on that. Also, to my mind, I think the analysis has been really grounded in pre-internet law. The tort case, Tomna, was all about traditional old-fashioned tort law in their analysis. The must-carry case, Moody, was all about the same cases that a con law professor would have told you this case should be about if you'd asked 10 years ago. So that's good. Some interesting sort of justice alignment things that are going on for those keeping track. So some of the rulings came out looking really apolitical and unanimous. That's always nice to see. Some of them split some of the conservative justices in a way that really tracks the way that conservative or right-wing political thinking has been splitting generally in the US, which is you get some justices who are being kind of pro-business and saying these are private companies, platforms are private companies, they can do what they want, that kind of thing, and other justices who are more focused on what I'd call culture war issues, and saying, look, the problem here is that liberal elites are censoring conservatives, and so you get this split where Alito and Thomas and Gorsuch go down it's reductive, but the culture warrior direction, and Amy Coney Barrett, Brett Kavanaugh, and Justice Roberts stick with this sort of more traditional conservative approach to these questions. Barrett and Jackson kind of teamed up in interesting ways in being careful about the details, which is charming. Can you say two incredibly powerful people are charming? It was charming. And then there was an interesting thing where justices who had experience working in government, particularly Kagan and Kavanaugh, would jump in and be like, yeah, the government does this all the time. And the rest of the justices didn't know that. So there was this division in what it is that they knew. Okay, with that sort of pulling out the themes, here are the cases. Twitter versus Tomna was the one case that got a big, real, meaningful ruling in the 2023 term. This is a case, as I said, about whether ranking algorithms can create liability for harms from ISIS attacks. And the way the case was set up was they isolated, in one case, a different case called Gonzalez v. Google, there's a question of whether the platforms are immune from these claims under the immunity statute, Section 230. And then in a separate case, this one, Twitter versus Tomna, the court asked, well, assume there's no immunity. Can the plaintiffs win this case anyway? Can they prevail on these claims? And the answer was no. there is just way too attenuated to say that what platforms were doing in hosting and having ranking algorithms with ISIS content was the source of the harm. And this is a case that people seem to forget about immediately and sort of like act like it wasn't very important. And I think it's really important. This is the first time that the Supreme Court is telling us what basic tort liability would look like for platforms in the absence of Section 230. It's not that it's saying platforms would win every case, but it's giving us the framework. And that matters for a future where 230 goes away. That matters for the kinds of claims that are not immunized by Section 230 today. So copyright claims, claims about prostitution and sex trafficking, all the criminal law federal criminal law claims. There are all these claims that it matters for now. Also, it turns out that when platforms litigate 230 cases, they're often briefing the merits. They're making the arguments that are from TOMNA, and then sometimes courts rule on that basis. So this is a live and kicking area of law, and TOMNA like tells us some super important stuff about it. Some kind of things, noteworthy things about it. So first, a lot of people, possibly including me, thought, oh, they have to talk about the free expression rights of users and how those will be harmed if the liability regime incentivizes platforms to go too crazy removing things. And there were some amicus briefs. There was one from the Center for Democracy and Technology that did a really good job of making this argument. Happily, I think this is good, the court didn't go anywhere near that. You know, they just stuck to the narrow tort question. They answered the tort question. They moved on. The other noteworthy thing about TOMNA, and this matters less than it did a year ago, is it's an opinion by Justice Thomas, and it acts like platforms are just these like passive, neutral conduits that don't make any choices about content, which is A, nonsense, and B, was basically Thomas creating a bunch of really useful quotations for Texas and Florida to use in their must-carry cases, saying, look, these are just passive common carriers. Of course, the government can make them carry things. That was weird. And it got corrected in Moody. The Moody has a factual description of what platforms do with content that talks a ton about content moderation, about trust and safety, et cetera. The other case, Gonzalez v. Google, this is the half of the ISIS case that's about Section 230. They were like, nah, we don't need to rule on this because we already ruled in TOMNA. And for anybody who sees this issue come up again, is there immunity for ranking decisions under Section 230? And it might come up again under a case called Anderson versus TikTok that just came out of the Third Circuit. Please be aware, tens of thousands of lawyer hours were invested in briefing like every possible argument on every side of this issue. I feel like it's almost malpractice to not go look at those briefs and just like invent the arguments that you think might make sense now without checking them. This is a list of some of the ones that I think are useful. Moving on to the 2024 cases. So last term it was technically 5 cases, but it led to 3 opinions. There were the 2 cases about the must-carry laws in Texas and Florida, which got issued under the name of Moody. There's the one case about informal government pressure on platforms, and then there's the case about government actors themselves when they're on social media. I will give this one the shortest shrift just because I think it's less relevant to platform regulation per se. But this was a redo of an issue that was much more high profile in a case about then President Trump's Twitter feed, and whether if you are a state actor, such as the president, and you are using a nominally private social media account to do governing stuff, then are you subject to the First Amendment? And the redo in Lincoln v. Freed and the companion case that went up involved some far less conspicuous state actors, a local councilman, some school board members, and it led to this kind of like, okay sounding standard that you can assign First Amendment obligations if the official actually has some state authority and they're purporting to exercise that authority in whatever it is they're doing on social media. And in the case of Mr. Lindke, they said he's not subject to these First Amendment obligations. All right, the must-carry cases. So these are the ones that, in my world, got the most attention. They were about these two Texas and Florida laws. They're big, messy, complicated laws, but some takeaways about them. They were explicitly politically motivated to stop censorship by liberal elites in Silicon Valley. Things like that got said in the governor's signing statements, and the legislators said it. It was quite clear. They're both really long and complicated. Florida has these weird provisions saying that if somebody is a journalist or if they are a candidate or they're talking about a candidate, then the platform can't moderate their speech freely. So like I can put up a lying, fraudulent promotion for my muscle building supplement and then mention a political candidate, and then it can't come down in Florida, is the theory. Both laws also had this idea that platforms were going to have to be value neutral or viewpoint neutral in moderating user content. And it was unclear exactly what that meant, but an example that I think is really telling that came out in oral argument in a back and forth between the Texas AG's lawyer and Justice Kavanaugh was, well, of course platforms can take down pro-ISIS content, as long as they also take down anti-ISIS content. So like how you achieve balance is by banning all speech on a topic or allowing every possible side, no matter how horrible, of speech on the topic. The laws also had some important and kind of like didn't get enough attention rules about procedure for content moderation and transparency. There were rules requiring platforms to notify users and, in Texas's case, let them appeal after a content moderation action. This is something that has been widely demanded by civil society around the world for years. It's part of the current European laws. That part did go up to the Supreme Court for review. And then separately, there were some kind of familiar types of transparency mandates, like to issue aggregate reports about the number of posts moderated and on what basis. Those didn't go up to the Supreme Court. The platforms sued, or two trade associations, CCIA and NetChoice, sued on behalf of platforms, saying three things. First, they said these laws violate our First Amendment rights to set and enforce editorial policy. That's the issue that goes to the Supreme Court. Notably, there's also a really important issue about these laws affecting users' rights. The government coming in and saying, for example, yes, you can read the Twitter account or the X account you wanted to follow, but only if you also read these other things that we forced X to carry, or maybe X carries them voluntarily now. But so James Grimmelman had a great brief, or I think it was Gautam Hans with James, had a great brief on the listeners' rights angle there. I filed a brief with Jack Balkin on behalf of Francis Fukuyama, talking about how a less restrictive means would be to empower users to have more control rather than having the state come in and provide top-down mandates about speech. There are very much users' rights issues, but they kind of disappear as the case gets litigated. Platforms also said these laws violate Section 230, and they said that they violate the Dormant Commerce Clause, that this is something that states can't unilaterally do, because then you'd get a 50-state patchwork of communications laws, that this needs to be the federal government. I'm going to linger on the circuit court rulings just because ultimately the cases get remanded, so knowing what the circuit courts did before matters. In the 11th Circuit, reviewing the Florida case, the court said these laws, the must-carry provisions, violate the platform's First Amendment rights to set editorial policy. And then they said that the notice requirements also violated the First Amendment because it made it so every time that platforms wanted to make an editorial choice by moderating content, it added this meaningful additional cost. But it upheld some of the other transparency provisions, which again, like there'd been this much briefing on them, and then the court provided this much analysis. So everything's a little messy when it comes to those. And by the way, if you want it unmessy, I have a law review article, Platform Transparency in the First Amendment, I think it's called, that is a very deep dive on the real First Amendment issues here that none of these courts got to. In the Fifth Circuit, things went like way off in a Fifth Circuit direction. For those of you who aren't lawyers or law students, the Fifth Circuit has a reputation at this point for being not just far right, but like far right in a way where they feel like they could just make up some new law and the Supreme Court might angrily reverse them a bunch of times, but they can't catch them all. So they went full Fifth Circuit. They said there's no relevant First Amendment rights here for platforms. They said platforms are basically being frivolous or lying when they say these laws are going to force us to carry Nazis and pro-Nazi speech and Holocaust denial, which anyone who's had anything to do with content moderation or just like the internet generally knows, yes, that is precisely the problem that these laws would create. And then it upheld everything else about the laws too, including the notice and appeal and transparency measures. So at the Supreme Court, the ruling was relatively simple. So first, all of the justices agreed that based on what had been argued so far, they didn't have enough information to just strike down these whole laws in their entirety. The justices were asking questions at oral argument that nobody had really expected and nobody had briefed about, well, maybe it's not okay to make YouTube be viewpoint neutral, but what if we made Uber be viewpoint neutral in deciding who to give rides to? Or what if Etsy had to be viewpoint neutral about who can sell tchotchkes? Or direct messages or email, all of which are interesting questions. It might be, at least in the Texas law, that the law doesn't cover that stuff anyway, but nobody was prepared before the court to make that clarification and kind of cut short that line of thinking. And so how it comes out in the ruling is everyone agrees we cannot accept this facial challenge to the law. Platforms, you have to go down and keep litigating, either bringing as applied challenges, saying this violates, as applied to the YouTube homepage, this is unconstitutional, et cetera, or trying to prove that there are so many bad applications and so few good ones that you really can bring a facial challenge. This might make everything about litigating cases like this just more expensive and complicated and give legislators pretty bad incentives to keep passing these laws that are just like a giant incomprehensible hodgepodge. So this may prove to be a rather problematic part of the ruling. Then the majority of the justices said in what I think was technically dicta, technically not a binding part of the holding, but they said it really, really firmly that yes, for the core platform features like the YouTube news feed, like the Facebook news feed or like YouTube recommendations, of course the platforms have First Amendment rights to set editorial policy. So we have a majority saying that very strongly and sending the case back down for re-review in light of that. And then they didn't resolve the question about the notice and appeal rules either. They said, lower courts, please review in light of what we've said about that also. I won't read my May 2024 prediction, but I found it because I was taking my old slides and updating them. And I was like, hey, I totally called this. So there was a bragging pause. Okay, what's going to happen on remand? I don't know. I think there are so many options of what the parties could do. And so what they have done so far, at least in Texas, is to go back and say, no, really, a facial challenge is okay here because all those hypotheticals about direct messages and email and Etsy, the law doesn't cover that anyway. The actual scope of this law is all the stuff that the Supreme Court said is unconstitutional. So that's what they have done so far. But, they could keep litigating on that ground. An individual platform could come in and litigate on an as-applied ground, saying, well, for this feature, I want you to say it's unconstitutional. The net choice or some new claim could shift to litigate based on Section 230 instead of the First Amendment, because that'll be maybe cheaper and faster. They could litigate the Dormant Commerce Clause issue. I kind of wish they would because it's so important, but it's maybe a loser of an argument and it's expensive and it involves discovery, so I don't think that'll happen. They could litigate about the other transparency mandates. So right now those mandates have been the ones that didn't go to the Supreme Court, have been upheld in both the 5th and the 11th circuits. on a preliminary injunction standard. They failed to convince a court to immediately order the lawmakers not to enforce this law. But they could litigate more and say, no, wait, we're going to convince you now. And they could also say, I think rightly, that their arguments are stronger. They could even seek a new preliminary injunction saying our arguments are stronger now because of what the Supreme Court said. All right. Moving on to the last case we're going to talk, last Supreme Court case to talk about, Murthy versus Missouri. This is a case about jawboning, which is the inelegant term for when people in government put informal pressure on maybe anyone, but in our case, platforms, to take down particular disfavored speech. So the government is not using normal legislative processes. They're bypassing checks and balances of various sorts, and just getting what they want through maybe a backroom conversation. So the claim in Murthy is that a huge long list of individuals and agencies in the Biden administration violated the First Amendment by pressuring platforms to take down a bunch of content, including COVID vaccine skeptic posts and so forth. And just to be super clear, this is a claim that the government violated the First Amendment. You see a lot of talk in this space about, well, maybe YouTube violated my First Amendment rights. So far, courts have been quite consistent in saying YouTube is not the government. It does not owe you First Amendment protection. So this isn't a case about what platforms can or cannot do. It's about how the government can or cannot interact with platforms. The district court in this case issued a ruling on 4th of July, which is a federal holiday, so somebody had to work through 4th of July to get this thing out, with this long list of factual findings, some of which looked really damning, like ugly emails from the White House. But it turned out that a lot of those factual findings were inconsistent with the record. There were, it was saying quotes that weren't really there. It was recontextualizing things that were relatively innocent and making them sound really bad. So this case was kind of tainted all the way through the process by this bad factual record that it started with. It gets to the Supreme Court to argue the same day as a much more straightforward jawboning case called Vulo, which is about an insurance commissioner in New York who was allegedly threatening to enforce laws that usually go unenforced against insurance companies unless they cut their ties with the National Rifle Association. So the claim was she's trying to suppress the NRA's pro-Second Amendment political speech and doing it through an abuse of authority that violates the First Amendment. I belabor that because we ultimately kind of get more analysis that's relevant in Vulo than we do in Murthy. So here's what I think is the hard version of the jawboning question. I think most of us would agree that if the government is going in there and really coercing platforms, like threatening them and getting them to take down speech that they didn't want to take down, that sounds super problematic. That sounds like the Bantam Books case, which is the seminal mid-century case about how you can't do that to bookstores. But the harder question is, well, what if the platform just doesn't care and they want to do the state's bidding because that makes their life easier and improves their relationships, and they're like, yeah, just tell us, whatever it is, we'll take it down. In that situation, does a user have no claim against the government? I feel like platform passivity shouldn't totally obviate the possibility of recourse for individual speakers in that situation. And the Fifth Circuit had, I think, useful doctrinal analysis saying, look, we think there are two ways to violate the First Amendment. One is through coercion, and the other is through this other thing called substantial encouragement, where there's almost like an employer-employee relationship, and the platform's just doing what the government says. So Murthy kind of fizzles out at the Supreme Court. We don't reach those questions because the court says, you know what? These plaintiffs haven't even shown that there's enough of a real problem here that they can get in the courthouse door. And part of why the court says that is it's related to the hard question that I just talked about. The court's like, well, it seems like the platforms wanted to do this anyway. Seems like even if they win this case, it's not going to cause the platforms to put their content back up, which is probably true. But then if you have this bad dynamic of a totally, bootlicking passive platform that wants to do whatever the state tells it, then the plaintiffs can never get into the courthouse on this standard. So I worry about it. Meanwhile, Vulo comes down and is ruled as basically like a straight coercion case, so it doesn't have to encounter this harder version of the question. All right, one last slide on pending cases, and then I will sit down and talk to Nate. There is one very relevant case that the court has already decided to hear this term, FSC, Free Speech Coalition versus Paxton. This is about another Texas law. This one isn't a social media case. It's a case about pornography sites or sites that have 1/3 or more pornographic content. And it requires them, among other things, it requires them to verify users' ages or to try to check users' ages through various mechanisms spelled out in the statute. And the Free Speech Coalition, which represents adult entertainment businesses, sued, saying this violates the First Amendment. How do we know? Because there was a case just like it 20 years ago that went to the Supreme Court. And the Supreme Court said, if adults have to show ID every time they're trying to access content they have a legal First Amendment right to access, but that has social stigma attached to it, it is going to stop them from doing that. They will be chilled out of exercising their First Amendment rights, and there must be a better way to do this. There must be a less restrictive means of protecting children from pornography, which is the state's goal, such as controls at the device side, parental controls, controls on browsers, et cetera. So that's what happened last time. That's what the district court said in FSC v. Paxton. But then this case, too, goes to the Fifth Circuit, and the Fifth Circuit, like super duper Fifth Circuits, in this case, they ignore the Supreme Court precedent from 20 years ago, and they instead apply a case from the 1960s about magazine sales. So presumably, the court is going to smack down the Fifth Circuit in some way, like yell at them and say, you did it wrong, but maybe there's been a big cultural shift such that something substantive will change about the analysis of that question. Interestingly, there was a brief filed, recently by an age assurance vendor telling the Supreme Court, hey, we've got a less restrictive means. If the porn sites had to use our technology, that would solve all the problems with this law. So that matters for platforms for a number of reasons, but the most obvious one, is that there are a half a dozen or more cases going on in lower courts about whether platforms can be compelled to do age verification, and also whether they can be subject to some other rules for child protection. And so if FSC, the Supreme Court case, tells us something new about when and how age verification can be mandated, that will be kind of like an earthquake in those lower court platform cases. What has happened so far is that 6 separate state laws have been struck down as unconstitutional on kind of a melange of grounds because the laws vary. The one that's farthest advanced is Net Choice v. Bonta. That one has a Ninth Circuit ruling, and so conceivably that squeaks in the door for Supreme Court review this term. I don't think they want it. I think they're tired, but that's my predictions are not always right. There's also one, and probably soon there will be 2 First Amendment challenges to state platform transparency laws. X challenged California's law, saying it violated the First Amendment, and prevailed. The Ninth Circuit agreed. There's another case where Stanford's own Eugene Volokh is the plaintiff, and I think also the lawyer, challenging a New York state transparency law requiring platforms to disclose information about hate speech policies. And he won in the first instance, and we're waiting to see what the Second Circuit will say about that. So those also could squeak in the courthouse door. And then finally, there's this case I mentioned earlier, Anderson versus TikTok, where the Third Circuit did something I think is kind of crazy. Basically, so this is a case, it's horrible facts. These cases are, I don't need the slides back. I can stop talking soon. It was a child who died after engaging with a blackout challenge on TikTok, like awful, awful facts. And the legal question is very much like the one in Gonzalez. It's whether the plaintiff can say, well, the problem here isn't the videos. The problem here is the ranking algorithm that TikTok used to display this. And so that's not immunized by Section 230, and that's something we can hold them liable for. So same issues, legally, same issues as in Gonzalez. The Third Circuit does this thing I think is really bonkers, but it is the thing that Clarence Thomas keeps inviting everyone to do, which is it says, oh, well, in Moody, the Supreme Court said that algorithmic ranking to enforce content moderation rules is the platform's protected free expression. So if it's the platform's expression, it can't possibly be immunized by Section 230 because 230 is supposed to immunize you against claims about user expression, which, if true, would just totally gut 230, right? Like the point of 230 was to give the platforms the legal protections they need to go out and actually do content moderation. As the literal drafters of Section 230 said in an amicus brief back in Gonzalez, of course we knew one way they were going to moderate content was by organizing it. In fact, we put the word organize in the statute to describe what it is that immunized platforms do. It would be, if every time that a platform exercised its editorial rights, like we want them to do, they simultaneously sacrificed their 230 immunity, this statute would mean nothing. It would protect nothing. It would not achieve the goals we set out to achieve. So I think that the Third Circuit's analysis of Moody is super bonkers. There's a petition for a bigger panel of the Third Circuit to rehear the case en banc, and so possibly it'll get reversed there. Or again, maybe that one squeaks in the courthouse door to the Supreme Court this term. All right, that's my spiel.
So I suspect that there are a lot of questions. So raise your hand if you've got questions. I'm going to start since I don't want to run out of questions here, or I don't want to go too long. I'll start with folks in the room. If you're on Zoom, put the questions in the Q&A. We have a tradition here in the law school that Mark Lemley gets the first question. So we'll go Mark Lemley, then Frank Fukuyama, and then others. Yeah.
So this is a sort of a little bit of a kind of broader look question, but so one of the things that was notable. Oh, sorry. One of the things that was notable about the Moody case, right, is this sort of unanimous agreement that facial challenge is inappropriate. But that's not the only case. There are like 3 cases this term where the court basically said, hey, facial challenges, oh no, those are terrible, right? Bring back an as-applied challenge. And I guess I'd love to hear a little bit about sort of like whether we think this is actually going to be taken seriously as a new form of constitutional analysis, because if it is, it seems to me to pretty fundamentally change how one would actually litigate these cases, whether you can actually strike down laws and so forth.
Yeah, so I've definitely heard a number of First Amendment litigators sound the alarm about this one, because there has always been the sort of encouragement in the law to bring facial challenges in First Amendment cases or from the court. And the idea that that sort of weapon might be taken away and that you might have to litigate a bunch of things piecemeal instead is, if taken seriously, would really change how First Amendment litigation works. I've definitely heard a lot of people being like, they don't mean it. But how do you test that, right? So in the oral arguments before the Ninth Circuit in the Net Choice versus Bonta case, the panel got very interested in this question and were asking the advocates, how do we break this into pieces? They got into, angles about, are the pieces severable? Well, severability is a matter of state law, not federal law. Do we have to ask a state court? How do we break this down? But what they ultimately did seemed kind of reasonable to me, and I hope that there is some kind of reasonable path for a lot of these cases, which is they sort of broke out chunks of the law and they were like, this whole part, the part where platforms have to make sure children aren't harmed by the following list of bad kinds of content, that part's unconstitutional. And then the sort of other parts that posed harder questions they sent back. That's not a great answer, but that's what I've seen happening.
Which kind of is a facial challenge, right?
Yeah, it's a facial challenge to part of the law. Yeah.
I'll just add one thing here, which is that the Roberts Court has massaged the facial as applied distinction for the last 15 years, so that in the election law area, in fact, my students who are in my election law class just learned, if they never learned about facial challenges before, they just learned about it. And it's happened in the campaign finance cases, it's happened in the voter ID cases, happens in some ballot cases. So, but interestingly enough, in a case like Citizens United, they end up striking it down wholesale, but that's only after an earlier case where they kind of lay the groundwork with these as applied challenges. Interesting, and just so people, the non-lawyers in the room understand, right, as applied, usually you come in and you say, this is unconstitutional as applied to me, and then you get an exception for you and people similarly situated to you. Facial means that it's unconstitutional in most or all of its applications. In the First Amendment setting, we've generally relaxed the rule on these facial challenges because we're worried about the chilling effect on non-parties before the court. Let's go to Frank, unless you want to have something else to say there. Let's go to Frank Fukuyama.
Daphne, could you say something about Ethan Zuckerman's case where he's basically challenging the platform's ability to eliminate intermediaries, which affects, the whole prospects for middleware?
Yeah, so I love this case. It's a little bit of a hack. It might get dismissed for lack of standing. But this is Ethan Zuckerman he's not, I'm going to call him a computer scientist. He's a complicated mix, but he is building a tool that will automate the process for Facebook users to unsubscribe from following people. And so it's, as he sees it, this is empowering users to make choices in a simpler way than Facebook is letting them make those choices. And historically, people who made tools like that got threatening letters from Facebook, from Meta. In fact, somebody who made a effectively identical tool a year or two ago got a threatening letter from Meta. And so the idea that you might get sued for building something like this seems pretty realistic in light of that history. So he's suing to get declaratory judgment that what he's doing is okay and doesn't violate various laws. And the interesting hacky part is he's using this this part of Section 230 that doesn't get nearly enough attention, which is a protection, Section 230C2B. It's a protection for people who distribute tools that users can use to exercise control over the content that they see. And it says distributors of these tools shall be immunized from, I don't know the exact language, but shall be immunized. And so he's saying, you know what I'm immunized from? I'm immunized from Facebook suing me, which definitely wasn't what Congress had in mind, but does seem to be what the language says. That it's not a perfect theory. There's still other claims Facebook could make that wouldn't be blocked by this theory, but it will be really fun if the court takes the bait and actually talks about this stuff.
Doesn't this tie in a little bit to the parts of the net choice case that they didn't address? So in this situation, right, there's a sense in Ethan, by the way, he's a professor at UMass Amherst, used to be at MIT Media Lab. So he doesn't want to have to pay a penalty, but they could kick him off the platform. There's nothing that's going to stop them. He doesn't have a constitutional right to stay on the platform, right? It's just a question of whether he's going to end up being liable to them, and right? Isn't that ultimately what that case is about?
So I think they have a right to, I don't know. This is complicated.
Because otherwise, if the law is interpreted in such a way that basically he is, by virtue of common law or statute, he has a constitutional right to be on the platform and to impose this middleware solution, right? Then it starts looking a little bit like common
right.
carry.
But he's not saying he has a constitutional right.
Yeah, no, that's what I'm saying.
Yeah.
What is he saying? It's
Well,
like he's saying that he can't be punished.
Well, what does it mean to say that the platforms have a right to kick him off? Right now, what it means is they can use legal tools to stop him from coming back, and he's trying to get rid of those legal tools and make it so they can't use the law that way.
Yeah, that's what I was going
Right,
to say.
but they can use technical means to try to block him.
Right.
And there are various baby legislative proposals out there to try to make it so that platforms can't do that. That gets really complicated really fast.
I want to go to the next question, I think, over here, but let me ask one in the middle. I want to, since you've written early on about the fact that platforms should be immune, that platform algorithms should be immune in the say under Section 230. I'm caricaturing it a little bit, but you can add flesh to that. As we think about the interaction between Moody and this Third Circuit Anderson that's going up to the Supreme Court, could you give a minute as to why you think it's so clear that the algorithm is that they are immune under 234 algorithmic choices that they make in ordering speech? Because I think, and you talked a bit about it, but that's, when you talk to reform groups, right? When they'll say freedom of speech doesn't include freedom of reach or something like that, or they'll say that, look, the platform's own decisions to amplify terrorist content, self-harm content, whatever, those they shouldn't be immune from. So first, what do you think? Why is it so clear that Section 230 does immunize them? And then secondly, in a non-230 world, why is it important that they get immunity for the algorithm?
Yeah. So I think one reason is this sort of logic I spelled out earlier about how the pro-moderation goals of 230 would be defeated if platforms could only ever take things down or leave them up. They couldn't use any of the other normal editorial tools of newspapers arrange stories on the cover or on a different page. This is very much part of what editorial judgment does in the real world. Secondly, there's this word organize in the list of characterizations of platforms that are protected under the law. There's a third thing, and I'm forgetting it. But to move on to the policy consequences, so I filed a brief in that case with the ACLU, and we argued very strongly that this just brings all the problems of content moderation into the ranked features of platforms. If platforms didn't have legal protection for their users' speech generally, they would be incentivized to err on the side of removing anything that carries legal risk generally. So you would see Me Too posts coming down, you would see satire and parody coming down, et cetera. That is a recognized problem. That's why we have laws like Section 230 and like the DMCA for copyright. But the reality is that how most of us consume social media today is we look at an algorithmically ranked feed in something like X or Instagram or Facebook. And on YouTube, 70% of video views are from recommended videos. Like the real world of how speakers reach audiences and audiences find the voices they want to hear on social media is very much mediated by algorithms. And if we said, nope, that part isn't immunized, then either the platforms have to super sanitize the ranked features, so we just get this Disneyfied version of X or Instagram or YouTube or whatever, unless we already know what to dig and go looking for, or they have to, avoid ranking and have YouTube show you videos in chronological order of when they were uploaded. It's kind of bonkers. And the justices recognize this. Several of them spoke to it in oral arguments. Like the idea that you can take the scale of content being generated on these platforms and then just not try to organize it for people defeats the purpose of the platforms.
let's go that question. Yeah.
Thank you, Professor, for the lecture. And I'm curious about the transparency law because in your article you argue for a democratic self-government model instead of the consumer model in net choice. I wonder, are there currently any like transparency law that support this kind of model, and is the Bonta case a good case or?
Yeah, so the distinction that I try to draw in the article is I'm actually quite worried about transparency laws that open up the door for the enforcers, who are going to be attorneys general, who are generally very political actors, open up the door for them to go in and say, well, you say you have a policy against homophobia, but it looks like you're taking down this other thing that's definitely not homophobic. And, there's just all this opportunity to probe the actual underlying editorial decisions and try to influence them in the name of transparency, and to do so even unwittingly. I think it's very easy for this to happen. I'm also worried about the burden of transparency exercises driving smaller platforms to become more and more sort of standardized and boring. I think that there are versions of transparency that raise these problems a whole lot less. And the primary examples are things like allowing researchers to scrape platforms. So just go out and make copies of whatever is out there. There's no gatekeeper deciding what the researchers can and cannot see. Maybe to open up APIs with specified data so then the researchers can pull data from there. Anything where it's just like, there's a bulk disclosure of information or a bulk access to information, and then the researchers can go do what they will to it, has fewer of the First Amendment risks I'm worried about than a law where it's like, well, we want to know about this kind of speech, and we want to know about that kind of speech, and we want, I hope that makes sense. So something that's where the enforcement is going to be about deciding whether something has been rightly categorized as violating a particular rule.
We got a lot of questions online in this vein as well from other parts of the world, actually. And part of the question is on, let's say, like takedown requests, any. So obligations to report why you did X or Y. Where does that fit into what you just said? Because the researcher access, I understand, but reporting obligations on content moderation, do you think those are dangerous?
Unfortunately, in this case, yes. It's funny. I find myself broadly supportive of a lot of the transparency provisions in the Digital Services Act in Europe because I think their enforcers aren't going to be as totally political and wacky as ours. So it's possible I'm being a little bit inconsistent here. But the Florida law had a private right of action for people who thought that their notice hadn't adequately explained why their YouTube comment was moderated. And they could win, I think it was $30,000 every single time that they went to court and convinced a judge that YouTube's explanation of why, haha, this sucks, violates their rules, or whatever the comment is. Any time that they say, and a judge agrees that an explanation was inadequate, they can get this sort of jackpot. This I think is part of the burden analysis, was definitely part of the burden analysis that drove the 11th Circuit's decision in striking that down. But you can see how that kind of thing could easily be abused, and in aggregate, could drive platforms to just change their policies to something so crisp and clear that it can be explained easily. Have a block words list so you can never say the word Nazi in any context, rather than having some complicated, nuanced rule about when and how you can talk about Nazis.
Well, but so one of the questions that was asked online is about, all right, so if you were to write a law like this, right? I mean, aggregate, so disclosure laws about, we took down this many posts for hate speech reasons or spam or whatever. Those I don't think, do you have a problem with those under the First Amendment? And then secondly, some of these user appeal questions, is there a way to write it in a way that it's First Amendment safe?
I don't think there's a way to write it that's like zero problems, First Amendment safe. But you can imagine variants that are like, your rules have to be spelled out and the hate speech rule is 1 and the subpart about race is B and the subpart about historical context is B2, and you specify you came down because of this sort of branch on the published rules, so that there isn't an additional nuanced explanation every time. That seems better. It doesn't fully avoid the problem. This is hard for me, as you know, because I really like transparency. I want more transparency. And so, I would be happy to try to figure out what the least abusable version looks like. But I do think the underlying most important thing is is scraping, is where researchers just go out and get the data and, don't have to have some interaction with a government official or a court or a platform.
But that wouldn't prevent the platforms from kicking the users off, right? You're just saying that they should be immunized under common law and criminal law.
Well, I mean, you could do it a couple of different ways. You could say they may not kick these scrapers off.
Right.
Or you could say you can't
then
sue
this
them.
is okay. Then they'd have a statutory right to access to. Then they must carry Ethan Zuckerman.
Well, but it's not that they must let Ethan Zuckerman listen.
Yeah. No, that's right.
I mean, I don't want to brush this off too much. There are bad guy scrapers out there, and trying to figure out a law that adequately distinguishes good guy scrapers from bad guy scrapers and tells platforms what they're supposed to do when they think it's a bad guy, but maybe it's a good guy. It's a mess. Like, I don't think there's going to be a perfect law, but I do think it's a more fruitful direction.
Next question. We got one up here. And this actually is probably the last question. Right behind you.
Thank you. So first of all, I'm really concerned about the blank slate that the Moody, like the blank check that the Moody case give to like editorial decisions of blank, like First Amendment protection. Because I'm thinking, like, for example, when we're talking about if regulation wants to make the platforms allow, for example, the Zuckerman tools, or allow, or a regulation says that, you should allow users to have their own moderated moderation tools or whatever. Will a platform have the same claim to say, like, oh no, that's you're violating my First Amendment right, because that violates my editorial rights? And just to follow up that, so a lot of, for example, this specific case was followed by a lot of international digital rights organizations, because it has a lot of impact of how we understand content moderation. So if you provide some comments of the Supreme Court effect that it will have in further in international interpretations of.
Yeah, I'll start with the second question. I think U.S. law is quite unique in this regard. It's an area where other countries are less likely to follow our lead, both because we go further in having speech rights for corporations. We have less of a concept of quote-unquote horizontal human rights, where there might be a human rights or constitutional right against a private company in Germany or in parts of Latin America in a way that doesn't exist here. So I think we got into some uniquely U.S. American territory with this case. To your first question, just because the platforms have a First Amendment right doesn't mean everything that burdens it is unconstitutional. And so the kind of seminal case here is a pair of cases about cable companies, the Turner case, where the court in the first one said cable companies have a First Amendment right to select what channels they want to carry. And that's editorial expression. And then in the second one, they said, but Congress can override that in this particular case because they've presented sufficiently strong justification and because the mandate is content neutral, et cetera. So in that case, the justifications that the court pointed to were if Congress sees a market failure, like a competition reason to need to intervene, the court talked about sort of what would be called media pluralism in other parts of the world, the desire for diverse and antagonistic voices. We're not so into that here anymore, but other parts of the world are more. And then specifically the desire to sort of preserve local broadcasting, make it be able to exist at all as a medium. So there are cases where you can have a First Amendment right for a platform or for a cable company, and carefully drafted legislation can override it. And I think that carefully drafted middleware legislation, for example, wouldn't take away the platform's ability to choose their own ranking and content moderation rules. They just have to offer it side by side with others. There are various ways in which that would be less burdensome on their First Amendment rights, more carefully crafted, likelier to survive review, maybe, but it's different.
Okay.
Well, please join me in thanking Daphne Keller. Give the next slide. So next week, one of our former postdocs, who's now a professor at American University, Samantha Bradshaw, and leads a center there, is going to be talking about exporting autocracy, which is how foreign disinformation campaigns are undermining democracy around the world. And so come join us again next week, 12:40 for lunch, 1 o'clock for the talk. Thanks so much.